Intake. Hello, Harper Mediation Services. Hello. Hi. Okay. All right. Can I have your name, sir? Scott Howard. Hello, Scott. How may I help you? Okay. All right. Okay. So let me repeat what you said, just to make sure that I understand and hear what you have to say. Um, in March of last year, uh, Mr. Lowry hired people to do construction work around your condo. And before construction took place, you had a fence next to yours and your neighbor's condo, in between. Is that correct? Okay. Now, after construction, the fence was taken down and not replaced. So in April, you did an internal dispute resolution with Mr. Lowry, where you both agreed that Mr. Lowry would put up a permanent fence without a gate that would be placed past the sprinkler spigots. Is that correct so far? Okay, wonderful. Now, just so I understand, did you both have attorneys for that informal resolution session? You did. Okay. And what was the result? Okay. So just so I understand, after 6 months of getting Mr. Lowry to sign, he never signed. He never signed the resolution agreement. Okay. And are you still being represented by your attorney? Okay. Okay. Okay, so you're not being represented by your attorney. So your attorney recommended that you try ADR because he was going to cost you $30,000 to represent you. Okay. And that's why you came here. Okay. Wonderful. Well, thank you for calling. And obviously you've gone through a informal resolution session before, but obviously it didn't work out. So how did you feel about the resolution session as far as the process itself? Okay. Okay, so you thought it was good. So you thought it was good. It's just that, he never signed. Mr. Lowry never signed. I see. Okay. Well, if you are interested in doing a mediation, and it sounds as though you are, and your attorney recommends it, then I think that's a wonderful idea. Now, does Mr. Lowry know that you are calling? Okay, he does not. Okay, all right. Well, I mean, even though you went through an informal resolution session already, I'm not sure what that process was like, but just so we're all on the same page as far as what the mediation process is, it's much like a internal dispute resolution session. All the only caveat is that you have the option of making any agreement reached in a mediation session binding or non-binding. Both you and Mr. Lowry would have to agree to that. And as far as my involvement is, obviously, you called me. I am a mediator. Just a brief background. I've done neighborhood disputes or you know right, right, right. Those types of disputes. I've been doing those for quite a few years, and it's yes, exactly. Right. So, I mean, just to give you some insight into, what my involvement is, I am a neutral in this proceeding. I am, you know, completely unbiased. I have no decision power. All decision power is put on yourself and Mr. Lowry if you both decide to go through mediation. This is not a court. I'm not a judge. I won't be making any rulings. My role here is to facilitate communication between yourself and Mr. Lowry with the hopes that, you both reach a resolution. And that's one of the best things about mediation as opposed to litigation. One, the cost benefit, and I think the your attorney recommended your attorney recommending ADR kind of speaks to that. The fact that he was going to cost you $30,000 for him to represent you in a court proceeding, but that's one of the benefits of mediation versus litigation. Another benefit is that you don't have to worry about being stuck with a decision that you have no control over, and you just have to live with it. Um, in a mediation, you have the opportunity to have the final say or have input in the final outcome. So there is that, and also the time factor. In a litigation, you can file for court, but I mean the docket could be so long that you would have to wait months before having your day in court, so to speak. And that probably alludes to the $30,000 that your attorney was going to charge you for representation in this case. So I think the time factor is also important, and it sounds like it's important to you as well. So and that's another one of the benefits of mediation versus litigation specifically. So now that I've given you that, just to give you a brief introduction or a peek inside of the process itself, what would happen is we would schedule a day and time to that everyone would be able to come to the table and sit down and talk. And you know, what would happen is I would give my opening statement just to lay the ground rules and just go over the process again for yours and Mr. Lowry's benefit and edification. And from there, each of you will have the opportunity to speak, say how you see the situation and what you would like to see happen. And then from there, we create an agenda and I facilitate a discussion hitting on all of the issues and concerns that each of you have, moving forward towards ultimately an agreement, hopefully. Does that sound like something you'd be interested in? Okay, wonderful, wonderful. Well, as far as rates, yes, thank you for asking. As far as rates, at a minimum, I charge for a half day, which is 3 hours, and that's $100 an hour. Now, as far as payment and who would be responsible for payment, I would leave that up to your discretion. If you would like to pay for it yourself, or if you want the cost split between yourself and Mr. Lowry, that is also another option. Okay. So just so I understand, you'd be willing to pay for this yourself? I see. Okay. And you're sure? Okay, okay, that's fine. So just so we're all on the same page, I want to give you a agreement to mediate form as well as a confidentiality agreement. But before I do that, I want to contact Mr. Lowry, the person that you have this dispute with, and see if he would be willing to sit down and come to the mediation table. Again, this is completely 100% about self-determination. You know, both you and Mr. Lowry would have to agree to enter into a mediation. Otherwise, it won't happen. Um, right. Exactly. Exactly. So just so we're clear, I'm going to contact Mr. Lowry and see if he is interested in a mediation session. Now, I will need Mr. Lowry's information as well as yours to be able to contact the both of you uh, in the event that he's interested in mediation and or whether he is not, and just to inform you. Right. Okay. So Mr. Howard, Scott, what is your information? Okay. Great. And your phone number? Okay, wonderful. And what is the best time to reach you? Okay. And now, as far as a mediation session, do you have a particular set of dates that work best for you, or particular days that work best for you? Okay. Fridays or Saturdays work best for you? Any time of day in particular? Okay. All right. Wonderful. Okay. Well, then I will contact Mr. Lowry and let him know that you are interested in having a mediation session. And right. Exactly. Okay. Now I need Mr. Lowry's information. What is his address? Okay. Wonderful. And what is his phone number? Great. Okay, sounds great. Well, thank you very much, and I will get in contact with you either way, whether I hear from Mr. Lowry or not. All right. Thank you for calling, and again, I want to congratulate you on deciding to do mediation. You've chosen the process where you have the most control. All right. You have a wonderful day, sir. Okay. Bye. convening. Good afternoon. May I speak to Mr. Lowry, please? Hello, Mr. Lowry. This is Jason Harper. I'm calling from Harper Mediation Services. How are you, sir? Wonderful. Glad to hear it. Glad to hear it. The reason why I'm calling is because I had a phone conversation with a Scott Howard, and in regards to an issue with a fence, in between his and his neighbor's yard, and in between their property. And it was an issue between yourself and Mr. Howard. Are you familiar? Yes, yes. So just to let you know what I heard. The last year there was some remodeling, some work done on the property, and a fence was taken down for that work. And now there's been an issue with the fence being put back up and the like. So with that in mind, Mr. Howard told me that there was a internal dispute resolution session where both of you were represented by attorneys, and there was an agreement. There was an agreement reached in principle in the resolution session, but has not come to fruition. Oh, yes, yes, right. So with that in mind, Mr. Howard contacted me. I am a mediator in regards to having a mediation session between yourself, Mr. Howard, and me. Mm-hmm. Mm-hmm. Right. And I'd be more than willing to explain what the mediation process would be like, and I can do that for you right now. The mediation process is an opportunity to resolve a dispute in a safe and confidential environment or manner. Now, as far as the process itself, I mean, there are many benefits, and in regards to litigation, which is something that I know both of you were considering, there are many benefits to mediation as opposed to litigation, and one of which is, it's time. You can file for court, and you would wait months or possibly years to have your day in court. In a mediation session, we would schedule a day, and we would have it. We could schedule a meeting within a week or 2 weeks, and so that time is of the essence, in a sense. Also, from a cost standpoint, whether you were suing or he was suing, both of you would have to pay representation, and along with the time factor, there is a cost factor, and paying your representation during that time in between can prove extremely costly, and even more costly depending on the outcome of the court proceeding. So that's another drawback to litigation as opposed to mediation. In mediation, there is just a one-time fee, and a standard rate, and that would be that. And that's something that we can also talk about. Um, and also the final selling point or advantage of mediation versus litigation is your control in the situation. In a court setting, in a lawsuit, you are at the mercy and at the whim of a judge who makes the ruling. He hears all the facts, and not necessarily, and he may or may not hear the facts as you state them, or hearing what you have to say on the matter, but just hearing a certain set of facts and making a decision where you have no say in the matter. You have to abide by whatever ruling that is. In a mediation session, it's different. In a mediation session, you have the opportunity to say how you see the situation and what you would like to see happen, and have a real say and input into the final decision and the resolution that takes place, assuming you reach one. In which case, you would have complete say in that final decision that you would make with the other person. Does that make sense? Does that sound appealing to you? Wonderful, wonderful. Well, just to give you a little bit more information as to the process and what to expect and confidentiality, the process is, it's very simple. We come, and we can meet at my office, wherever the both of you feel comfortable. And the process works is, you would You would sit at the table, and I would give my opening statement as the mediator, and each of you will have the opportunity to say how you see the situation and what you would like to see happen. I would ask questions, just clarifying, and gaining just more insight into what you were thinking in the situation and what has taken place. And from there, the both of you are free to speak and to work together towards coming to an agreeable solution. Um, Also, another thing that I would like to talk to you about is confidentiality, and actually um, that's another plus as opposed to litigation. In a litigation, when you file for court, it's a public record that you are filing. In a mediation, everything is confidential. That is the name of the game. The only way it would not be confidential and the information would be available to the public is if both of you agreed to that, and and that is something that you're you're welcome to do, but just so you understand, mediation is a completely confidential and voluntary process. So you don't have to worry about it. It's the saying, what happens in Vegas stays in Vegas, and that's essentially mediation. So does that sound like something that you would be interested in? Wonderful. So if you are interested in mediating, in engaging in the mediation process, then that's great, and we can talk more about that. Now, as far as cost, uh, Mr. Howard is willing to cover the cost. So that shouldn't be an impediment to you or anything else that you would have to consider. The only thing that will be involved is your presence. Now, I know that you had representation the last resolution session that you had about a year ago. Um, Now, are you still represented by an attorney? You are not. Okay. Okay. That's fine. That's fine. And so in the mediation session, it would just be yourself and Mr. Howard and me, and those would be the so you and Mr. Howard would be the decision makers that will be present, and that's perfectly fine. Okay. Now, if you are agreeable to mediation, that's wonderful. I would like to confirm your information. Now, your phone number is okay. And just to verify your address, can you give me your address, please? Wonderful. Okay, so what I will do is I will send you the agreement to mediate form as well as a confidentiality document with a self-addressed envelope to sign, and you can return that back to me. Now, as far as a meeting, you know, I was speaking to Mr. Howard, and he said that the dates that he has available are Fridays and Saturdays. What works for you? Saturdays work for you. Okay. Is there a particular Saturday you had in mind? Okay. All right. Wonderful. Well then, I will see if Mr. Howard is available on that day. He should be. He said that Fridays and Saturdays were his availability days, and great, great. Okay, wonderful. Well, thank you very much, and I want to congratulate you on agreeing to mediation and trying it. And just so we understand, the day and time is and at wonderful. Okay, and the location will be in my offices. Right. Okay. You have a wonderful afternoon. Bye. Mediation session. Hello, and welcome to the mediation session. My name is Jason Harper, and I'll be your mediator for today. Just to give you a brief background into myself, I was trained at Loyola Law School, and I've mediated many community disputes such as this, and I have a passion for seeing people be able to resolve their disputes in a civil manner, as opposed to litigation, and just being able to talk things out amongst each other and reaching a resolution together, as a team effort. So I want to congratulate you both on deciding to go this route, and this is the first agreement, your decision to come here this afternoon. So with that, I congratulate the both of you, and with that in mind, we should get started. Now, just so I understand, if I could get your names, the exact spelling of your names, and how you would like to be addressed. So, how would you like to be addressed? Okay. Wonderful. Okay. And great. Great. Okay. Thank you very much. So we'll go on a first name basis. Scott, Michael. You can call me Jason. And as I said earlier, this is a mediation. This is an opportunity to resolve a dispute in a safe and confidential manner, where the two of you will work together to create a resolution that can result in a win-win situation for the both of you. Yes, do you understand? Okay, wonderful. Now, this is not a court. I am not a judge. I am a neutral. Um, so I will not be making any rulings. I won't be ordering you to do anything. And any decision that's made will be made by either one of you. Do you both understand? Okay, wonderful. As a neutral, I will not show bias to either party. In the event that that does happen, or you have the feeling as though I am showing bias to either party, please let me know, and we will stop, and we can talk about that, and we can choose to, end the mediation if you decide to do so. If you so choose. So right now we will go over the agreement to mediate form that indicates that you have entered into this mediation of your own volition and with the intent of reaching a resolution. Um, are you both interested in reaching a resolution today? Wonderful, wonderful. And I see that both of you have signed it, and I have a copy here, and I can make copies for the both of you if you decide to, if you would like a copy, if you don't have one of your own. Also, you have received the confidentiality agreement. And that I will go over with you briefly just to go over the highlights one more time. It indicates that anything said in a mediation is inadmissible in any legal proceeding unless all parties agree to it. Now, obviously, the exceptions to that confidentiality is if there was a threat of a crime or if a crime was committed during a mediation session. In that case, I would be compelled to report that to the authorities. Um, and also, as a mediator, I can be subpoenaed, but I will not give any testimony as to what took place during the mediation session. Obviously, with those exceptions being the exceptions. Do we understand? Okay, wonderful. Again, I have copies of the confidentiality agreement that both of you signed, and if you would like another copy, if you don't have one of your own already. Now, as we've talked about earlier, the process for this mediation session is as follows. Each of you will have equal time to say how you see the situation and what you would like to see happen. This will be your opening statement. After both of you have said your opening statement, we will work together to create an agenda that will address all of the issues and concerns that we talked about today, and we will work together to go over all of those issues one by one with the intent of reaching a resolution. If and when a resolution is reached, both of you have the opportunity to make the agreement legally binding. Now, legally binding means that any agreement that's made would be held up in a court of law. Now, in order for that to happen, both of you would need to agree to making any document legally binding. Do you understand? Do both of you understand? Wonderful. Okay. Now, during this session, there are ground rules that will be instituted. First is that there will be no talking, no one interrupts. If there is something that you have heard that you have a rebuttal for, or if you have questions about, you have both been provided with a pen and a pad of paper. If there is something that you hear that you have a rebuttal for or that you have a question about, feel free to write it down. And when it is your time to speak, you are more than welcome to address what you had heard that you had concerns about, and the other would have the same opportunity. Also, if you, I would like to ask both of you to act in good faith. You both came up in here under your own volition, and I believe as though the fact that you both decided to come here today says a lot, and that says that you are on some level interested in reaching some type of resolution, and I celebrate that. And I just ask that you continue that good faith and that goodwill towards each other, moving into through this process, and also that we show each other respect, and that's basically what these ground rules are for, to make sure that we show each other respect and open and honest communication at all times. So we understand. Does anyone have any other ground rules that they suggest? Okay, Wonderful. Now, at some point during the mediation session, we can initiate a caucus. Now, a caucus is a private, confidential meeting between myself and either one of you. Now, any one of us can call on a caucus, and what will happen is we will move to a private location where the two of us will speak. And unless given authorization, I will not share anything that's said in the caucus during the joint session or in a private caucus with the other one, with either of you. Do you understand? Okay, wonderful. Now, as far as a settlement, now reaching a settlement is great, but the main goal is to get to a place where we understand each other on a deeper level, and that's communication. That's the most important part of this whole process. So that when we communicate, when we understand each other on a deeper level, and we unpack all of the positions that we have, and we get to the interests and what our real concerns are, what our real fears and what our real goals are, we can find that there are things in common, and from there we can move towards reaching an agreement. Now, as for logistics, the bathrooms are located in the following places. Please let me know if you need a break. I have allotted 4 hours for this session. I know that we were scheduled for 3, but obviously I've allotted 4 hours. So if you need to take breaks, by all means, let me know, and we will stop. Now, please let me know if either one of you has any particular time constraints. Okay, wonderful. Now, and are all decision makers, are all pertinent decision makers present today? Great, great. So with that in mind, I'll ask you to please silence your cell phones if you have not already. And do we have any other questions before we get started? Wonderful. Well, again, thank you for choosing mediation. You've chosen a process that gives you the most control, greater than any other type of proceeding. So with that in mind, we should get started.